Basically, there was no connection between the king, Great Britain, and ourselves anymore. As far as the king was concerned, he still owned everything. As far as we were concerned, he didn't. But there was no legal connection because the king revoked all the charters. And we made our own statement of independence. And at that point, there was no government, not legally, so everybody became a sovereign. Okay? Now, there were some of us sovereigns who formed organizations that were formerly called colonies and now are called states. Okay? And so these organizations got together and they created this thing called the Confederation. Okay? And so they had the Articles of Confederation, and that worked for a while, but then it really didn't work, so each of the states sent their emissaries to a big meeting, and at that big meeting, the emissaries basically went off on a tangent and said, well, what we really need to do is just rewrite this whole thing. But this time, instead of the states doing it, they did it as people, still sovereign. And the theory they had was the Lockean theory, that Locke was the philosopher, as opposed to Hobbes. Hobbes said power comes from the top and goes down to the people. Locke says power comes from the people and goes up to the top, to the government. And so our basic philosophy is Lockean. And in the preamble, they basically said, we the people ordain and establish this Constitution for you guys over there called the United States of America. So we're still acting with our sovereign powers. And then what we said, if you read through the Constitution, toward the end it says that, okay, here's the game plan. And if 9 of you organizations that call yourselves states will come on board with this plan, then it's a go. If we don't get 9 of you at least, then it's a no-go. But the people put it together, proposed it, and said, okay, now you can volunteer into it, to the states. The states did volunteer into it, and so now we have the United States of America, and so they're contracted, and there's actually court cases that recognize that the United States of America, as is presently constituted, is by authority of the people and not by authority by the states, and the states are contracted in. And the people are still sovereign because it says we ordain and establish this Constitution for whom? For the United States of America. Okay, well, when we ordain and establish, what does ordain and establish mean? Well, the ordain part means to authorize, to make law. The establish means we actually put it on paper so you can read it, publish it, spread it around, create it. So we ordain and establish. Now, there's nothing about those two words, ordain and establish, that takes away from our sovereignty. We're still kings. Okay? Well, this is very painful to government. They couldn't stand that. So they had to figure a way. And don't underestimate these people. These people think in 100-year terms or 200-year terms. Okay? And one of the first signs of it, well, there are many first signs, of course, but one of the major first signs was when they took over the first mandatory public school. You see, you have to understand that when the United States broke away from England, we were a mature society. We were not just a bunch of colonists running around trying to figure out what to do. We had education. We had knowledge here. We had people who were experienced and educated in history and knew stuff. Do you realize that in 1776, Harvard University, which was owned by a church, was over 100 years old? Okay? So we're not just a bunch of bushmen running around in the forest wondering what to do. And we put together a really excellent system. In fact, the more I study it, the more I see, boy, these guys were sharp. But no matter how sharp they were, they did miss one point. At that time, and for many decades, all education pretty much was private. The parents got together, hired the teachers for their kids, They had local control. You've heard of local control for schools. Well, they really had real local control. They had real homeschooling. And so in the 1850s, the government, I don't remember which city it was, but the government brought out the military and escorted the first children for the first mandatory public school. And that was the beginning of the public school system in the mandatory sense. There were public schools, but that was the mandatory public school. Now, why was it so important? Well, they couldn't change the Constitution. There was too much resistance there, so they changed the education system. From the 1850s to the 1950s, they stripped out the subject of civics and replaced it with a new subject that you're all pretty much familiar with. It's called American government. You ever take that in school? American government? Social studies? Okay? They took out civics. What is civics? Civics, if you look in the dictionary, at least the one I looked in, civics is the study of personal rights. It's that branch of political philosophy dealing with personal rights. Well, once the government gained control of the curriculum, they stripped out the things that were troublesome to government. Things like your rights. So here we are again, okay, all of us basically are studying civics. That's really what we're doing when we go to court. Now, so like I said, from the 1850s to the 1950s, they stripped it out. That subject of civics, phased it out little by little. So from generation to generation, there might have been a deterioration, but it was not that visible what they were up to. But if you compare 100 years ago with today, or 150 years ago, you can see the difference. Okay? Now, but that still wasn't enough because the people were sovereign. And some people understood it, what it was. So they had the Civil War, and supposedly it was over the issue of slavery. I can tell you the official reason for the Civil War. The official reason I've actually seen with my own eyes. I saw the document that was signed by President Lincoln. It was on display at the Huntington Library. That document is privately owned, and they had it on display on loan to the library. And I happened to go there when I heard that they had this document. I wanted to see it, so I can say I had actually seen it myself. You know what it was? Lincoln attacked the southern states for failure to pay their taxes. That's the legal reason. Okay? Because you see, the federal government had to live off of the states. There was no income tax. So, and of course that's pretty bad too, because you remember, money is power. And the states were able to keep the federal government under control pretty much because they were the source of the money. And the federal government got quite desperate when a source of their income was going to try and leave. So they used force to keep them in the Union. So, anyhow, they had that little fiasco called the Civil War, and in 1868, they, again, using slavery as the excuse, they then came through with some amendments which supposedly helped to free the slaves. One of them, of course, was the 13th Amendment. I'm not talking about the lost 13th Amendment, but I'm talking about the other 13th Amendment, where the phrase where I guess the slaves were freed up. But the real thing was the 14th Amendment, because the 14th Amendment is the one that defined the term citizen of the United States. Now, you have two terms in the Constitution that are defined constitutionally. One of them is treason, and the other is citizen of the United States. There are no other definitions in the Constitution. And the citizen of the United States, well, what is it? What does it take to be a citizen of the United States? Well, you have to qualify. Okay? What are the two qualifications? That's what it names, two qualifications in order to be a citizen. The first qualification is you have to either be born here or naturalized. The second qualification to be a citizen of the United States is you have to be subject to the jurisdiction of the United States. See that word? Subject to the jurisdiction of the United States. That is the second requirement for being a citizen. You understand? Subject. The people are sovereign. They're not subject to anybody. At most, if you're one of the people of the United States, you are subject to your fellow sovereigns in the form of grand jury indictment and petite jury 100% conviction. Okay? That's a trial by the people, not a trial by the government. When a government does a prosecution, they prosecute on information. They appear with information before the magistrate. The magistrate functions like a one-man grand jury, decides whether or not there's a case there, and, of course, as we all know, he usually rubber stamps it to tell him go ahead and do the prosecution. And then you have the next trial, which they say you can have a jury if you're talking criminal proceedings, but in fact, those juries are advisory juries. Okay? About the only place I know where common law might be really used is in an actual murder trial, because they actually go and get an indictment. And, in other words, to a grand jury, they don't do it on information, they do it on indictment. But then that's questionable, too, because none of the grand juries in the United States have 25 people. It's always fewer than 25. That's a whole subject area of discussion right there. But basically, they typically have 21 or 23, but not 25. If they had 25, it'd be a real grand jury. So it's a legislated, statutorily defined grand jury rather than a common law grand jury. If you want a common law grand jury, you get 25. I've kind of played with the thought of what if we got 25 of us together and officially notified the government that we are a grand jury and then started investigating. What if we went to the court administrator and said, how about giving us a room we can meet in? But again, that's another topic. But if you do want to know about grand juries, read Article 61 of the Magna Carta, which is on this disc. And you'll see the entire procedure for setting up a grand jury and what the powers of a grand jury are. Anyhow, so the citizens are defined as people who are born or naturalized and subject to the jurisdiction. So if you're subject to the jurisdiction, now you're no longer sovereign. Okay, if you're subject to the jurisdiction, you have a master. After all, to be subject, you got to have somebody who's subjecting you. Okay? So, the preamble, let's look at this a little closer. Okay? We start off here. I kind of gave you the overview. Now here's the detail. The preamble does not specifically define the word people. Nevertheless, the definition becomes apparent in the context of the other words and prior history. And so, prior to the United States, before the United States existed, there was no legal government. A group of representatives acting in the name and by the authority of the good people of these colonies declared the independence of the colonies from the British Crown and the state of Great Britain. And so from the beginning in the 1776 Declaration of Independence, the people were acknowledged as a source of authority, that is, the sovereignty which authorized the Declaration of Independence. By the way, President Lincoln considered the Declaration of Independence as our first Constitution. He said there were 3 constitutions, and that was the first one. And some people are actually incorporating that in their legal papers, saying that that's the foundation that defines our system. Okay, so next came the Articles of Confederation in 1778. Then 1787, the people themselves came forth to ordain and establish this Constitution for the United States of America. And that gave us a preamble. So let's analyze that preamble, because I want you to get a picture of this sovereignty. Okay, here's the full statement. We, the people of the United States, in order to form a more perfect union, establish justice, ensure. So you have a laundry list of tasks. By the way, everything you see there, everything in there is an element of a trust. You've heard of trust? Okay. We have the people are the trustors. The trustees are the United States of America. The purpose of the trust to establish justice, ensure domestic tranquility, etc. Okay? And the beneficiaries of the trust are ourselves and our posterity. Okay? So, the United States of America is not a country. It's the states that are independent countries. It's the United States, that's a trust, a corporation. How can you tell it's a corporation? It's real easy. All corporations have presidents and vice presidents and secretaries and treasurers. Okay? States have governors. Or countries have governors. Okay, so anyway, we go into the structure of this thing. Here it is. The trustor, we the people. The venue of the United States. The purpose, in order to form a more perfect union, etc. And get the blessings of liberty. The beneficiary, to ourselves and our posterity. The enabling action, do ordain. We declare the law. Enabling action number 2, and establish, bring into existence. What? This Constitution. Those are the articles of incorporation for the trust. You know, all corporations are trusts. Are you aware of that? Yeah. You know, just as a side note, I've always advocated, if you want to set up a trust, set up a corporation for profit or set up a non-profit corporation. To me, that's the best trust. Why is it the best trust? Because that's the trust that all the rich people use to protect their assets, their income, and get tax exemptions and the whole bit. And so, the IRS is not going to attack that trust. If you did everything according to that trust, you're basically pretty much immune from attack if you follow all the little rules. And the rules are designed so that the government gets no money. Okay? You know? It's not an accident that they're set up that way. You can set up other trusts, and other trusts are legally correct and everything, but what did you do? You ran up a red flag you ran up to Jolly Roger on the flagpole, right? You said, come get me. So you can be right, and you can get a nice fight on your hands, maybe. I don't know. But just as a little aside, I like corporations and non-profit corporations because of that. And I'm not taking away from the value of the other kinds of trusts. But if you really want to beat the system, that's how they all do it. That's why rich people don't pay taxes. What was it that Leona Helmsley, that's right. She said only little people pay taxes. Okay. So anyway, the trustee is the United States of America. And so here's the analysis here on this disc where it goes into that. It defines the context and in which the remainder of the Constitution must be interpreted. Most of it is self-explanatory. Here's an explanation that points to popular sovereignty. So, but basically the preamble, you see, when you talk to an attorney and you say, well, what's the significance of the preamble in the Constitution? And the answer I've always gotten was, well, there's really no legal significance, but it just kind of is an introductory kind of thing, you know. But it just kind of is an introductory kind of thing, you know. But that's not part of the Constitution. And he's right from his point of view, because the attorneys all deal with statutory law. They're all inside that shadow of the Constitution. Whereas the preamble basically sets the foundation for what this is all about. We, the people, ordain and establish this system for you guys over there. This is how we want you guys to run this for our benefit. These are your operating rules. That Constitution was not written for you and me. It was written for them. And it doesn't apply to you and me. We're in our sovereign capacity. We can dump that anytime we want.